Ms. Conley, can you start your video and unmute yourself, please? Calling the case number of SP4519123. This is the state of Michigan versus Mina Jenna Conley. Your appearance, please. That means tell me your name, ma'am.
Manaya Janae Conley.
Okay, and this is the date and time set for an informal hearing. It was set for 9:31. It's now 9:49. The officer has failed to appear. Therefore, this matter will be dismissed without prejudice. Any objection?
No.
Okay, but before that, ma'am, it's just not always going to be that easy because I would like to note two things. You're driving at a disgusting rate in a construction zone. You are putting your life and that of construction workers in danger, driving your car in such a manner. Okay? When I read this remark that says you are going 81 in a construction zone, that sends me. Okay? There is no reason in life, and you are not that important, for you to be driving so recklessly and selfishly on the road. And then I look at the ticket and the trooper gave you a deal and wrote you a ticket for 5 over, which was a gift, right?
Right.
Because 81 in a construction zone, certainly if I do the math, is not 5 miles over the speed limit. And instead of taking responsibility for that and taking the loss and taking the break from the officer, you requested an informal hearing on it. And the break for you today is the trooper did not appear, so the ticket will be dismissed. But all that shows me, the court, is the type of person and driver you are. That you would drive in a construction zone where there are workers. Don't roll your eyes at me. Don't roll your eyes at me. And get a break at the road from the trooper. And instead of being gracious and responsible, you pushed for even more consideration. And you get that break today on a technicality because the trooper didn't appear. But you better think long and hard about yourself. If you roll your eyes again, I'm going to set this for another.
Buckle up, guys. Today we're diving into 3 unbelievable courtroom moments. It starts light with a friendly host intro, but quickly teases the chaos ahead: a reckless driver, a bond-violating defendant who loses it in court, and a sovereign citizen trying to live rent-free. Before the drama unfolds, there's a quick sponsor plug, setting the stage for the legal fireworks we're about to witness.
Hearing.
I'm looking up. I'm looking in the background, never roll my
Okay,
eyes.
well, I would like you to look at me. There's no reason to be looking up.
Okay.
Show some respect and stop being such a selfish driver. And if you can't handle the responsibility of driving and the workers on the road, do everyone a favor and hang up the keys. Those men and women working out there are risking their lives. And the fact that you got such a break on the road and pushed it for a hearing today shows me that you think there are no consequences to your actions and you should just be excused for your selfish behavior. Learn that you exist with other people in this community and you are not important. You are not important enough to be driving and disregarding the other people and workers on the road. It is not about you. Slow down, be aware, and if you cannot be responsible enough, then don't drive because it's a privilege. Are we clear?
Yes.
Okay, you may leave the Zoom.
Alright, guys, here's where the tension begins. A Michigan judge calls out a driver who was caught speeding at a shocking 81 miles per hour in a construction zone. The officer didn't show up. so the case is dismissed, but the judge doesn't let her off easy. He delivers a scathing lecture about endangering lives, showing zero patience for her careless attitude. It's the calm before the storm as you feel the heat rising in the courtroom.
Thank you and welcome back. So we're going to begin in case number 25-4703FY. Mr. Ullman is appearing for arraignment in the underlying charges. He had one failure to appear, but we had renoticed that, so he's not facing any issues with regard to a failure to appear for the arraignment in this case. Just the bond violation issues.
Okay.
And arraignment in the underlying charges. So Ms. Ferrara-Wilbur, did you have opportunity to review the allegations on the felony complaint, nature of the offense, possible maximum penalties, as well as the issues with regard to the bond violations with Mr. Ullman?
Yes, thank you, Magistrate. We did have the opportunity to review the complaint and the alleged bond violations, as well as Mr. Ulam's rights in this matter. In regards to the underlying charges, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel. In regards to the bond violation, he also waives a formal reading, pleads not guilty, and requests that it's set for a hearing with counsel.
So we'll appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. Ms. Ferrara-Wilbur, is there information you'd like me to know regarding bond?
Yes, thank you, Magistrate. In this matter, we would request that the bond is reinstated. On May 28th, it was set at $25,000, 10%. As Mr. Ulam stated, he does part-time handyman work. He's currently homeless and has no access to funds for a bond, but he has taken steps to obtain a mailing address and has access to a phone to maintain contact with the court and to counsel in this matter. Thank you.
Well, at one point, he had posted the bond through bond bonding agency.
Now the real sting hits. The judge isn't done. He tears into her selfish behavior, calling out her reckless disregard for workers' safety. When she dares roll her eyes, he nearly resets the hearing on the spot. The judge's words cut deep, making it clear driving is a privilege, not a right. It's an intense, humbling moment that leaves her quietly defeated before being dismissed from Zoom.
We'll move on to case number 25-4779SM. And Ms. Ferrara-Wilbur, you had opportunity to review the allegations in this complaint, nature of the offense, and possible maximum penalties with Mr. Ullman as well.
Yes, that's correct. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel.
Based on the information that you've provided, I will appoint an attorney for you in this case as well. The next step in the process is a pre-trial conference. In this case, the pretrial conference would be scheduled for July 15th. It would be at 9:30 a.m. And again, Ms. Ferrara-Wilbur, information regarding bond.
Thank you, Magistrate. Based on the remand in the other matter, we would request a low cash bond in this matter.
So your bond in this case is going to be a $10,000, 10% bond. Conditions on this bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You would have an immediate urine screen and twice, we'll say 8 times per month, urine screens hereafter. You'll have no contact in any manner whatsoever with Darcy. Means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with her. You will stay 500 yards or more away from her. You may not be at any address that she is or may be. Specifically, you may not return to 811.
Moving on. The stakes rise as we meet a defendant facing bond violations and a brand new felony. Initially, he had a $25,000 bond, but after crashing out, it's gone. The courtroom atmosphere grows heavy as the magistrate explains he'll now sit in jail, awaiting his next hearing. You can almost sense the frustration building on both sides. And you know this isn't going to end calmly.
All right, parties. I'm gonna figure out, and then we'll determine whether or not how we're gonna proceed. How we're gonna continue on. So I need both of you to unmute for me.
Yes, sir.
All right. Both of you raise your right hand for me. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
I do.
So let me first get a little bit of basic information. So Trust Property Services, do you guys have is this a commercial or residential?
This is a residential property.
All right, great. And when was the lease entered into?
March 25th, 2019.
Okay, when was it last renewed?
It was renewed on, it was signed on March the 9th, 2022.
Okay, and has it just been renewing every month since then?
Yes,
I mean,
sir.
every year on a yearly basis.
Yeah. Every,
okay. All right. So technically renewed again on March 2025, but I understand that there's allegations of default before then. So how much is monthly rent?
$17.50.
Okay. Is there a late fee? If so, how much?
There is a late fee, Your Honor. The lost discount is $100, and then there is a $10 per day additional rent, but I understand you have it capped at 10%.
Yeah, so we can do it at 175, which would be the most. When's the last time the tenant paid rent from any source?
That was...
Here the drama thickens. The same defendant is arraigned on fresh charges. He pleads not guilty and asks for a low bond, but as the conditions are laid out, he starts pushing back. Confusion over his home address and restrictions sparks a heated exchange. The tension simmers as he struggles to keep his cool, setting up a showdown you can feel coming just seconds away.
On the ledger there, it was February 25th, 2022.
That's the last time he paid any rent?
Excuse me. No, sorry. That was when he started paying rent again. So previously he got behind significantly, and the county stepped in and
Objection,
paid.
Your Honor.
Okay, well, he can tell me what he wants to say. Overruled. Continue.
Okay.
Okay.
And March 25th, 2023 was the last time rent was paid. So we began accruing rent at April 25th, 2023.
Okay, well, your complaint doesn't ask for all of that. It says that it is from December 25th, 2024 through March 2025. So explain that to me.
I did not file it myself. My assistant has been in the hospital 4 times, and some weeks at a time. So I'm not sure what was filed.
Well, that's a concern because you're pursuing this. And got that this was filed back on, this was filed April 8th or April 18th. So this is well after that. Well, for an opportunity for you guys to make any additional determinations. I just want to make sure we have some clear numbers, because the numbers that you're asking for in the complaint that was past due in April of $10,000, that was for rent through March.
Could you state, I'm sorry, sir, could you state that amount again? The thing went in and out.
Past due rent of $7,000, and that's for the months of December 25th through March 25th, 2025.
Yes, sir.
Okay, so I just want to make sure that you're aware of that. I understand that you're the agent, but so he hasn't paid rent, at least according to the complaint.
And there it is. The defendant finally flips. His sarcasm spills out, mocking the process, interrupting the judge, and showing zero respect for the court's orders. In a split second, his bond shoots up from $10,000 to $25,000. It's a classic case of talking yourself into deeper trouble, proving sometimes silence really is the smartest move in court.
And so with due process under law, because I have a lot of evidence showing that I did my due process and did not receive that from them. Basically, that $7,000, he's saying that they just submitted a ledger to you guys saying that $65,000 is owed. And saying
I haven't seen that ledger.
But
so
he just said at the mediation I'm not assuming.
So just hold tight.
Yes,
Let
sir.
me
Yes,
ask
sir.
you,
Yes, sir.
why don't
I'm just saying I got a lot of stuff, and it's a
you
real
let me
case.
just, and then we, if need be, I can get into all of that because right now,
Yes, sir.
one, what you discussed in mediation, I'm not aware of, right?
Yes, sir.
So,
Yes,
so
yes,
I
sir.
all of that, that's why I like to ask my questions. And then
Yes,
I
sir.
can,
I just wanted to make sure I got on record that I do challenge that we should even be in this court.
and I would say if that's the case, did you file
I will.
but you haven't. So you have not sought to have the case removed to federal court, have you?
Not the federal yet. I was trying to get removed just the superior.
Okay, and under what basis?
Under the basis of equity. This is a rent-to-own case. This is not a normal tenant
And
landlord situation.
I would pause you because I'm very familiar with that. And if it's a rent to own situation, those generally are still considered contracts. You may have a lease, otherwise. And so, just before we get
I
into
got
that,
okay.
because I've been doing this a little while. So,
I'm with you. I'm with you.
all right. So tell me, is rent $1,750?
Your Honor, I'm not aware of what the rent is currently.
Well, you told me that you signed a contract back in
The
2022.
contract that I signed, the rent was not. If you review
Oh, how
the
much
contract,
is it? How much is
the
it?
rent that I signed at the time the contract was $1,450.
Okay, 1450.
It was $1,450.
Just getting information.
Yes, sir.
Okay.
I'm with you.
Did you submit your last contract online? Did you submit it as part of your evidence?
The contract, no, neither one of us submitted the last contract signed. I can't produce it, but I did not submit the last.
So hold on.
Now we head into the final case, and it's wild. A so-called sovereign citizen hasn't paid rent in 18 months, but insists he's owed equity. The landlord calmly explains the unpaid months and mounting late fees, while the judge tries to piece together the messy timeline. It's the perfect setup for what's about to be one of the strangest courtroom rants you'll ever hear.
Okay. And so, just to kind of get some clarity, December of 2023, that means all of 2024, and now we're moving into 4 full months of 25. And then if I were to give a writ, right, you would have 7 days. I understand you saying you ain't got no jurisdiction, all that stuff. I just want to understand what I'm working with. So it essentially would have been 16 months plus 13 days. Now, that's not what they're asking for.
Correct.
But you're saying you haven't paid rent at least for about 16 months.
Correct.
Okay. And is there any basis of why you've not paid rent for 16 months?
Yes, sir. They have some funny accounting. And so I submitted in accordance with UCC and all other statutes and legal statutes. I submitted a request for accounting, a full request for accounting, which I have a right to do. I submitted it under certified mail to the registered agent's address per the law. The registered agent received the first letter. I have all received, everything's in front of you in the submitted stuff. I submitted a document requesting a formal request, asking and saying that I would pay whatever was needed as long as they produced actual documents, especially because they're filed under a trust. So they're supposed to complete certain things as a part of their business model of how he's even running his business. And so I asked for that to be produced, and I would pay. The first one came to them, they received it, then they closed it back up, taped it up, and they rejected it. I sent two more. One of them I sent notarized, which is the big envelope you have. I sent a notarized copy. You also have a copy of what I asked and requested from them under the law. They ignored them 3 times. Then didn't ask for any rent for a year, Your Honor. And then when they did send me a notice to pay or quit, it was for $6,500, and now the $7,000, which is what you're looking at.
Here's where it goes off the rails. The sovereign citizen launches into bizarre legal theories, challenging the court's jurisdiction and claiming rent-to-own rights that don't exist. The judge, unfazed, dismantles every argument with firm clarity, exposing the nonsense. It's both cringeworthy and fascinating as the excuses fall apart. If you enjoyed this wild ride through courtroom chaos, hit that like button, subscribe for more, and we'll see you in the next video.